Also, Jim Crow laws mandated racial segregation, while males and females have almost always shared communities and homes. So the integrative function of schooling might be less vital when it comes to gender than race. Complicating matters, officials and decision makers historically justified many restrictions on women as benign and protective. Justice Ginsburg reflected on the contrast between racial and sex-based discrimination during her confirmation hearings before joining the United States Supreme Court. She said, "Race discrimination was immediately perceived as evil, odious, and intolerable. But the response I got when I talked about sex-based discrimination was, 'What are you talking about? Women are treated ever so much better than men.' I was talking to an audience that thought I was somehow critical about the way they treated their wives and their daughters." To individual women, restrictions often did not seem benign. In 1974, Susan Vorchheimer sought admission to Central High School in Philadelphia, an elite college preparatory public high school restricted to boys. Who here went there? Anybody? Okay, I knew it. She saw nothing benign in being barred from that school, and nor did she accept the alternative offered to her, the separate neighboring Philadelphia High School for Girls, which lacked the endowment, science labs, and distinguished history of Central High. Think about the names. Central High for boys, high school for girls, The very difference in the names signaled the difference in the significance of those two schools. A federal district court agreed with Susan Vorchheimer. It found unacceptable the absence of a co-educational option for students seeking an academically rigorous public high school. The appellate court reversed. It said boys and girls are really different. A dissenter described the result as separate but equal and objected. Susan Vorchheimer pursued her case to the Supreme Court and received support from Ruth Bader Ginsburg and her ACLU Women's Rights Project. Although Justice Ginsburg described her disappointment with the presentation by Vorchheimer's lawyer and did not participate in the reply brief, and maybe later we can hear about the brief that she wrote that didn't get filed. At the Supreme Court, Vorchheimer's lawyers challenged the separate but equal approach on the grounds that in the context of subordinate place assigned to women in society, no school sister to Central can supply an educational experience generally equal in character, quality, and effectiveness. One justice was missing for health reasons, and in 1977, the Supreme Court justices split 4-4, producing no decision and leaving in place the appellate decision that affirmed the single-sex policy. Later, before she herself became a Supreme Court justice, Justice Ginsburg commented that the Vorchheimer case had been brought too soon because the justices then serving on the court were not yet ready to understand that preserving all male institutions conveyed a tacit message of female inferiority. Challenges to gender exclusion in education continued in the courts. In 1979, Joe Hogan challenged his denial of admission to the baccalaureate program in nursing at the Mississippi University for Women, and he won. The Supreme Court ruled 5-4 that the exclusion of men violated equal protection. Interestingly, that university has kept its name, still Mississippi University for Women, despite a claim that that name might deter some men from applying. In light of the Hogan decision, 3 plaintiffs in 1984 renewed the challenge to the single-sex admissions policy of Central High School in Philadelphia, this time in state court, and this time they won. That court cited the disparity in resources invested in the two schools and rejected the male-only admissions policy at Central High. Meanwhile, the alumni, teachers, and students of Girls High organized to defend that school as a place that empowered girls. And to this day, it retains its mission of advancing women's success and its name of Girls High. In 1992, the Federal Department of Education investigated Girls High and found no violation of equal treatment because boys could apply. Apparently none has. This asymmetrical approach, allowing all girls' school but not all boys' schools, appeals to some who defend all girls' schools as redressing historic discrimination while rejecting all boys' schools as unfairly exclusionary. In fact, nationwide, the Federal Court of Appeals decision in Vorchheimer allowing single-sex public education for both boys and girls remains the last word of federal law on the subject. I thank Liz Schneider, who's here tonight, for encouraging me to write about the Vorchheimer case, and publishing the chapter in her book, recently published, Gender Law Stories. New arguments for single-sex public schools did mount in the 1980s. A man named Spencer Howland and others argued that male role models and discipline could engage inner-city minority boys in education in a way that female teachers could not. He urged schools to address low self-esteem and alienation among boys who often had no adult men in their lives. Detroit, City Council and Board of Education noted that 80% of the males in Michigan's criminal justice population had attended the Detroit public schools, and that black men in Detroit died at almost 15 times the national average rate for all men in the country. They planned to offer 560 seats in specially designed all-male academies. 1,200 applied. The National Organization of Women's Legal Defense Fund challenged the plan, noting the bleak prospects for black girls as well. Local groups criticized the National Women's Group as an unwelcome interloper. A federal court halted the boys-only admission policy with a preliminary injunction in 1991, and a similar effort stopped in Milwaukee. During the 1980s and 90s, public school districts increasingly admitted girls to all boys schools where no comparable opportunities existed. But public systems still preserved many all-girls schools and promoted some new ones, claiming tradition or informal policy or success in warding off the handful of boys who expressed interest. Many people rationalize the coincidence of two notable developments affecting single-sex education in the summer of 1996 with this kind of asymmetrical approach. That's when the Supreme Court rejected the exclusion of females from the Virginia Military Institute at the same time that New York City announced plans to create an all-girls public high school for low-income families in East Harlem. By then, President Bill Clinton had appointed Ruth Bader Ginsburg to serve as an Associate Justice of the United States Supreme Court. President Clinton compared Ruth Bader Ginsburg's role in the women's rights movement rightly to the role that Thurgood Marshall played in the struggle for civil rights for African Americans. And as a lawyer, Justice Ginsburg had worked to establish sex-based distinctions as worthy of the same judicial vigilance as race-based distinctions, and she achieved partial success in cases calling for intermediate scrutiny, though not strict scrutiny. The question of scrutiny arose again with the challenge to the male-only admissions policy at the Virginia Military Institute known as VMI. Its administration maintained that some students, especially adolescents, benefit from single-sex education, even though evidence on the subject was limited. One witness argued that females and males learn differently. Males need the kind of grueling discipline used at the school, but females do not. The lawyers introduced expert witnesses to address alleged differences between male and female students. The Department of Justice, in contrast, maintained that the mission of developing citizen soldiers would not be defeated by including some women in the class. The school rejoined by citing the work of psychologist Carol Gilligan. Said, see, she talks about gender differences. Carol Gilligan said, hey, wait, they didn't ask me. And she submitted a brief to the appeals court in support of gender integration, stressing that her research had identified tendencies in groups rather than characteristics of individuals. The trial court upheld the gender exclusion based on generalizations about males and females and assessments of group averages. The ACLU Women's Rights Project attacked this approach and emphasized that the constitutional guarantee of equal protection of the law is a guarantee for individuals, not about group averages or stereotypes. The Court of Appeals for the Fourth Circuit concluded that the state school could not proceed as it had and faced three options. It could admit women, it could create a separate parallel institution for women, or it could become a private rather than a state-supported school. Virginia decided to create a separate program for women. The Department of Justice continued its challenge and argued that the new state program launched during the litigation at a small private liberal arts college would not offer the same rigorous military training, facility, courses, financial opportunities, reputation, and connection with distinguished alumni that the Virginia Military Institute provided its male students. Indeed, the alternative for women did not even try to offer the key elements of the VMI program. After arguments at the Supreme Court, The Supreme Court majority rejected the program for women as faulty and insufficient. It also rejected Virginia's historic exclusion of women from the military academy and other educational opportunities. And writing the opinion for the court was Justice Ruth Bader Ginsburg. In that opinion, Justice Ginsburg expressed, and I quote, skeptical scrutiny of official action denying right or opportunities based on sex. Virginia failed to show, quote, exceedingly persuasive justification for the exclusion of women. Virginia's hastily erected alternative women's school was patently inferior, given that the court did not need to resolve whether single-sex education could ever be equal. But even as the court debated the VMI case, plans for the high school named the Young Women's Leadership School in Harlem unfolded. A national correspondent for the NBC News, Ann Rubenstein, in 1985, asked a teen mother in Milwaukee at a daycare center for teen parents where this young girl imagined herself 5 years later. The girl started weeping silently. At that moment, as Rubenstein later described it, she realized that the girl, and I quote, knew she was doomed. She knew she was locked in a cycle that happens when a teenager has a baby, particularly an underprivileged teenager. She knew, and I knew, that had a profound impact on me. I knew based on that moment that we were not doing enough. The daycare center wasn't enough. We had to get these young women on a different path. So Rubenstein decided to launch a public high school to offer at-risk girls better options. She and her husband used their money, social networks, and media access to create this new school. And it succeeded. It became a model and a spur to public and private philanthropic investment in all girls' schools. The Young Women's Leadership School recruitment materials emphasize that it's not designed for gifted students. It's a public school. It does receive financial and programmatic assistance from a private foundation. That foundation, in turn, effectively lobbies for federal and state aid for similar schools elsewhere. And after its first 10 years, that school reported 100% attendance, compared with 60% nationwide, or citywide, and 100% of its graduating students were admitted to college. When the school was founded in 1996, however, 3 months after the Supreme Court rejected the all-male military Institute's single admission policy, some women's rights advocates denounced the school while others celebrated it. The New York Civil Liberties Union, the National Organization for Women, the New York Civil Rights Coalition challenged gender as an admission criterion at the school, and the U.S. Department of Education Office for Civil Rights indicated a preliminary finding that the school's policy, like the Detroit all-male academies, seemed to contravene Title IX. I know from the interviews that I've conducted with members of the Clinton administration that this was somewhat of a crisis for them. They didn't know what to do. They had advocates, supporters who were pushing them to challenge the school. They had others who were defending it. Torn between the competing arguments over gender neutrality and enhancing opportunities for low-income girls of color, members of the Clinton administration, I'll tell you later who they were, they decided to temporize and do nothing. Over time, they began to view that school, the Young Women's Leadership School, as perhaps an affirmative action remedy, and maybe it would survive rather than challenge Title IX. But the clock ran out, and a new administration came to Washington and embraced single-sex education. George W. Bush included single-sex education as a plan to leave no child behind. Starting in 2001, the Department of Education identified single-sex education as one of its priorities and developed a rule to allow it and promote it. The stated reasons were to encourage the diversity of educational options and to meet the needs of specific students. Issuing a final rule, the Department of Education clarified that single-sex options had to be voluntary, and that the evaluation of substantially equal opportunities for boys and girls should include intangible features like the reputation of faculty, along with other considerations. But in a really big departure, the federal rule permitted classes to be offered to students of only one sex with no comparable alternative.